you so much for being here today, everyone. Good afternoon, and thank you for joining us for the final round of the 97th Annual William Minor Lile Moot Court Competition. My name is Ariel Vasser, and I have the privilege of serving as the president of the Lile Board this year. Before we get started, I just wanted to go over a few quick logistical matters. First, we ask that you please refrain from entering or leaving during the arguments to avoid distracting our competitors and judges. And second, please ensure that all phones and other electronic devices are set to silent for the duration of the event. I also have the privilege of introducing our distinguished panel today. First, we have the Honorable Liam P. Hardy of the United States Court of Appeals of the Armed Forces. Judge Hardy earned his BS from Princeton University and his JD cum laude from Georgetown University Law Center, where he served as the senior administrative editor of the Georgetown Law Journal. He clerked for Judge Margaret A. Ryan of the United States Court of Appeals for the Armed Forces, Judge David B. Santel of the United States Court of Appeals for the District of Columbia, and Justice Clarence Thomas of the Supreme Court. He has worked in both private practice at Kirkland & Ellis and in public service as a Deputy Assistant Attorney General for the Office of Legal Counsel in the Department of Justice. Justice Hardy is a lecturer at Harvard Law School, and he was nominated to the Court of Appeals for the Armed Forces in 2020. Next, we have Chief Justice S. Bernard Goodwyn of the Supreme Court of Virginia. Chief Justice Goodwyn graduated magna cum laude from Harvard University and received his JD right here at the University of Virginia. While at the university, he was an editor for the Virginia Tax Review, a member of the Raven Society, and a recipient of the Ritter Award. He began his career at McGuire Woods in Charlottesville before moving to Norfolk, where he specialized in commercial, constitutional, and insurance defense litigation and became a research associate professor at the law school. He was elected to serve as a district court judge in 1995, where he was the first Black judge on the Chesapeake District Court, and spent 10 years as a judge in the First Judicial Circuit Court in Chesapeake, Virginia. In 2007, Governor Tim Kaine appointed him to the Supreme Court of Virginia, where he is currently serving his second term. And finally, we have the Honorable Chad A. Readler of the United States Court of Appeals for the Sixth Circuit. Judge Readler teaches seminars at both the University of Michigan Law School and Moritz College of Law at the Ohio State University. He received both his BA and JD from the University of Michigan, where he graduated cum laude. He clerked for Judge Alan Norris of the United States Court of Appeals for the Sixth Circuit before joining Jones Day in Columbus, Ohio. Before joining the bench, Judge Readler successfully argued an actual innocence claim before the Supreme Court of the United States in McQuiggan v. Perkins, has represented capital defendants before the 10th Circuit and the Supreme Court of Ohio, and was a recipient of the American Marshall Memorial Fellowship. Judge Readler also served as acting United States Attorney General for the Civil Division of the Department of Justice, where he litigated cases on behalf of the United States in federal courts across the country. In 2019, Judge Readler was confirmed to the Court of Appeals for the Sixth Circuit. Thank you all for being here today. I would like to invite another Lile board member, Mr. Braedon Sims, to come up and provide a brief overview of the problem for this year's final round.
In September 2023, a man attempted to rob the First National Bank in downtown Minor Lile. After noticing an off-duty police officer, the suspect fled the scene. To locate the suspect, FBI agent Christopher Dugan issued a geofence warrant to search the geolocation data of Google users who were present around the bank at the time of the robbery. This led him to Clyde Longabaugh, who was convicted of attempted bank robbery and brandishing a firearm during the attempted robbery. After his conviction, Longabaugh moved for a new trial. The district court denied his motion, finding the geofence warrant was constitutional and the sentencing enhancement was proper. This appeal presents two questions. First, did the warrant violate the Fourth Amendment? And if so, does the exclusionary rule apply to the evidence derived from the warrant? Second, are robbery and attempted robbery crimes of violence for the purposes of 18 U.S.C. Section 924C? Both are issues of first impression in the 12th Circuit. At this time, please rise for our panel.
Webb for appellant, Clyde Longabaugh.
Ledet for appellant.
Meinerding for the United States.
David Bainbridge for the United States.
Please be seated. Counsel, you may proceed.
Your Honor, at this time, we would like to request 2 minutes for rebuttal. Each of us will argue for 14 minutes.
All right.
May I proceed?
Yes.
Good afternoon, Your Honors. My name is Lance Ledet, appearing on behalf of Appellant Clyde Longabaugh. May it please the Court. The government's request in this case is astounding. Its theory would allow it to indiscriminately search any nearby user's data any time any crime occurs. That means suspicion turns only on whether someone is in the wrong place at the wrong time. But the Supreme Court has consistently rejected that principle, and this court should too. We ask this court to reverse for 3 reasons. First, because Agent Dugan conducted a search. Second, because he did so unreasonably, pursuant to an invalid general warrant. And finally, because good faith does not excuse reliance on a general warrant. So first, Agent Dugan conducted a search by accessing data capable of reconstructing people's movements in 80 acres around a downtown area.
Can I ask you a question about that?
Yes,
So,
Your Honor.
am I right that in the record that there was a video camera that captured your client entering and leaving the bank?
You're correct, Your Honor.
So why is that any different than geofencing or technological capabilities that are recording basically the same kind of conduct? Because you didn't challenge the camera as a search, right?
That's correct, Your Honor. We did not challenge the camera as a search. And the key difference in this case is that surveillance cameras are fixed points. They're only in one area, and they have natural technological limitations like frame rate and resolution. But here, the geofence data was able to retroactively reconstruct and place a person in any kind of intimate place.
So it's kind of a funny rule. The more rudimentary the technology, the more likely it is to be able to be used. It seems that sort of with these great tools, right, that advanced technology, and you're arguing that technology is, I guess, a negative for law enforcement.
That's not our rule, Your Honor. That's the Supreme Court's in Carpenter. There, the court told the government to get a warrant where it accessed data capable of revealing intimate details about an individual's life. And in so doing, it considered the nature of the data sought as well as whether that data was shared in a meaningfully voluntary way. I think our colloquy is getting at that first factor.
But in that instance, counsel, weren't they following a person for like months?
In Carpenter, that is
Yeah.
correct, Your Honor. But our point is that because
Don't you think that's different than asking whether or not you were at a bank when it was robbed?
Sorry, I didn't understand your question, Your Honor.
Don't you think that is a different situation than the one in which you're trying to find out whether a person was present at a bank when it was robbed?
Because of the level of precision of this data, Your Honor, our point is that a 30-minute expanse of an 80-acre area was capable of revealing details, catching an individual in their home or a church. You're right in this instant matter that Longabaugh was caught in a bank. But the Supreme Court hung its hat in Carpenter, not on the result of a given search, but rather on the capabilities of that data itself.
And that seems like you're hanging this, so like 0.1, a 1/10 of a mile would have been okay, but 2/10 of a mile was too much?
Our point is that it depends on what is included in that area. So for example, here, the record reflects on page 4 below that this was a downtown area. So our point is this, Your Honor.
But it only captured 32 people.
That's
at
right.
step 1, right?
That's correct.
It's not
32
like we
people.
have thousands and thousands of people who were swept up in the warrant. And at a minimum, isn't this a question that was properly presented to the magistrate? I mean, the magistrate could have pushed back and said, you know what, 2/10's way too much, right?
You're right, Your Honor. I think those questions go to the validity of the warrant. But at a threshold, we have to ask if a search occurred. And Carpenter tells us a search occurs when data is capable of revealing an individual. Your point is well taken, though, that a 0.1, you could change the geofence at step 1, and that would change the capabilities of the data as to what is revealed at step 1. For example, we think that even 7 days of data only in an open field may not be capable of finding someone in their home or a place of worship or these other intimate spaces that the court in Carpenter seemed to contemplate. Our point here is that because this data captured users in a downtown area, that is the problem. That's why this data was capable of revealing intimate details.
So just help me, so getting back to the camera example, so cameras are okay, geofencing's not okay, but where's the line fall exactly? How much is too much? I guess how much information that's captured is too much? Do you have a rule, or do you just have examples, or?
We think the best rule is what the court in Carpenter told us, which is that the capability question matters. There, the court considered numerous factors. Duration is assuredly one of them. But the point is where the data is more precise, that duration ingredient in this question of whether data is capable of revealing intimate details.
The more precision, the worse off it is from a Fourth Amendment perspective.
That's precisely right, Your Honor. The more precision, the more capable the data
This
is.
is really counterintuitive from a law enforcement perspective, right? If someone's committed a crime, we want to catch them and put them in jail.
I think that's precisely what the rules adopted by the Supreme Court in cases like Riley with requiring a warrant for a cell phone and Carpenter requiring a warrant for location data contemplate, which is that if the Fourth Amendment means anything in the digital era, it's that this kind of information has to be guardable by a warrant requirement.
What kind of information are you talking about? In this particular instance, the only question is whether or not you were in a bank at a particular time. Is that something you have an expectation of privacy about?
Not a given space, like being in a bank, but the court in Carpenter focused on the ex ante question. Is the data capable of revealing intimate details? And our point is, at the beginning of this search, Agent Dugan knew not what he was going to catch in the 80-acre expanse of a downtown area.
Well,
but
what do
he
you
went
think he could
fishing
have
anyway.
called?
Sorry?
What could he have called other than where those people were located at a particular point in time?
Because this data is collected so frequently and is so precise, he could have found users in their home, in a place of worship, and those types of details would have constituted a search.
But isn't that exactly why they limited data to a certain time period and a certain location?
Yes, Your Honor, and if it was limited even beyond that to just this bank, we think a search may not have occurred. But because this was not limited to just the bank, and it swept in an 80-acre expanse of a downtown area, it was capable ex ante of revealing intimate details, and it was a search. I'd like to just note briefly that it was also data that was not voluntarily shared in a meaningful way. The government focuses extensively on the fact that this data was tapped once, saying, yes, I'm in to share this
How
data.
do you reconcile that position with the fact that 2/3 of users don't authorize this data? It seems like if 2/3 of people, the majority, opt out, it seems like there is a meaningful opportunity to opt out.
So that 2/3 number is misleading, Your Honor. It includes in it the number of total users, millions and millions of users that are never prompted in the first place. It includes, for instance, computer users that don't have location services at all, so they're never prompted. So we don't know precisely how many say yes and how many say no. But in any event, the fact that some people say no does not tell us whether those that say yes understand that choice. And that's our point. Here, Google told Longabaugh this service was needed in order for his phone to work. But that's a false choice, and it's not the meaningful choice.
What more would be necessary to make it meaningfully voluntary?
Two things, Your Honor. The first is the frequency with which this data was caught, and also an acknowledgement that the data would still be captured even after the app that asked Longabaugh to opt
I
in.
didn't understand the frequency point. You're saying how often they ask you, or what's the frequency point?
How frequently this data would be captured and collected. But moreover,
Well, I just don't understand. I mean, if it's constantly following you, that's a problem. If it's selectively following you, or what's the frequency measure? I'm just not following.
this data was captured once every 2 minutes, Your Honor, but no information as to that was provided to Longabaugh.
So what if it was capturing it once every 10 minutes? That's more permissible?
That would be a less precise data and perhaps would bear on the capability analysis, Your Honor. But our point is, on this
Well, I just
record,
want to, like we apply tests sometimes, right? Or we have factors. So
That's
just
right.
trying to understand some concrete factors we can apply to all this, and it's just a lot. It's feeling a lot of sort of
We
here
think-
and there, but I'm just trying to get some concrete examples of what would be okay. So too much frequency, but 10 minutes would be better. 2 minutes, capturing every 2 minutes is too frequent.
our position, Your Honor, is that at this record, nothing was ever told to Longabaugh about how much data was captured. Some kind of indication
So that's a
regarding
different point.
10 minutes or 2 minutes.
Okay, so this is a different point.
My point is that,
Well, I know this is different.
yes, Your Honor. So yes, 10 minutes would have made this data more revealing, And that would have made it less revealing. And that would have suggested that it was less capable of capturing information, revealing intimate details about his life. Our point is, because of how precise this data actually was in this factual record, it was capable of revealing those details. And so
why doesn't the appellant have, it seems like we're stripping him of his agency here. Like, we're going to tell him that your voluntary agreement to give this data is not meaningful. It seems like that was a big issue in Carpenter. Like, if you're going to use a cell phone, there the only option was to either use or not use a cell phone. Here, someone has a cell phone that by default doesn't collect this data, and they have opted into this, presumably for their own benefit, so that the apps and the experience on the phone is improved. Why can't we recognize that? Why can't we legally recognize that as his choice?
Because the data collected here was only collected after Google told him that it was necessary to turn on in order for his phone to work.
Was that not true? Well, not to say, I don't think they said it to work, but for the full experience to be enjoyed.
Well, Your Honor, Google said your phone, these apps need this to be turned on to work properly. And precisely because data apps like Maps and email are so very important, we think that's a false choice as
Now,
contemplated
the
by
government
Carpenter.
says the map function works fine even if you opt out of this data, that you can use the map to take you to a location.
That may be true as a matter of fact, Your Honor, but of course Longabaugh was never informed of that truth. And so our point is he did not have sufficient notice at the point at which this was
What would be
made.
sufficient in your mind?
Sufficient notice would have indicated some element of how frequently this data would be captured, but also the fact
Does
that it would be
anyone think about that? I've just never thought about this.
I thought that they watched you every second when they said that. so.
Your point is well taken, Your Honors, but the Supreme Court in both Smith and Miller contemplated that the defendant's knowledge of how frequently data is provided to, say, a bank or a cell phone company is relevant as to whether it's meaningfully shared. And we think that would be true here as well. I'd like to touch also on the warrant point in this case as well with my remaining time. This warrant, when Agent Dugan used this data, he conducted a search, but he did so unreasonably, pursuant to a warrant that was invalid in two different ways.
He talked to some other officers, right? He kind of like went around the office and said, what do you think? And is this appropriate police action? And the other officers said it was, more or less. Wasn't that enough?
So we think that the extent to which he asked other officers would go to the good faith analysis, Your Honor.
Oh, I'm sorry, I thought that's what you were getting to. Yep.
But we can discuss it. I think that it is relevant, obviously, to the ultimate disposition in this case. Our point is that it is not proper for an officer to execute a facially deficient warrant, irrespective of what his colleagues at the force say. And this warrant was clearly facially deficient upon receipt. When he obtained this warrant, the only constraining element, the only constraining language provided to him was, quote, based on the needs of his investigation. That's it.
Well, I mean, that's not true. I mean, he asked for a specific geographic location and a specific time. And isn't that exactly how the warrant was particular?
So that is one area in which the warrant was particularized. But as we brief, step one was overbroad because it included extraneous buildings, the whole downtown area, as well as failed to filter for individualized user suspicion.
But again, that's on the magistrate judge, not on the officer.
No, Your Honor. The Supreme Court in Groh versus Ramirez noted that because warrants that are facially deficient upon receipt, no reasonable officer can execute them anyway. The court,
So 0.2 of a mile is facially deficient, but 1/10 of a mile is perfectly fine.
the global command of the Fourth Amendment, Your Honor, is one of reasonableness. And of course, in this case, our point is that an 80-acre expanse of a downtown area captured 32 users whose only crime was being in the wrong place at the wrong time. But that could have been fixed by filtering users based on some kind of particularized suspicion.
But
For
isn't
example,
that how the three-step process works? I feel like, take for the example where he got on a motorcycle, the suspect got on a motorcycle and went north. Now say there'd been a toll plaza there, and they subpoenaed the records from the toll plaza, right? And this is Easy Pass, and they have thousands of toll plazas all over the country, but they say, we want the data from this toll plaza from this set of time to this set of time. How is that not analogous to what happened here?
Your Honor, I see my time is running low. May I have leave to respond?
Yes.
The reason it's not analogous here, Your Honor, is because in your hypothetical, it sounds as though there wasn't a search in the first place. That sounds squarely like something the third-party doctrine would govern. But here, at the point at which we're considering the validity of the warrant, we're assuming for purposes that a search occurred. And if a search occurred, there has to be particularized probable cause as to each individual expectation of privacy that an agent infiltrates. But here, there was none. And for that reason, when Agent Dugan received a warrant that at steps 2 and 3 constrained him not at all, he should have not executed that facially deficient general warrant.
And he shouldn't have depended on the magistrate to know if he was not entitled to that information? He should know better than the magistrate as to whether or not the warrant is valid?
It's not a question about second-guessing the magistrate, Your Honor. The Supreme Court in Groh noted that an officer has an independent duty to ensure that the warrant that they are executing gives them a constitutional basis for their authority. At times, that means when you see a warrant is deficient, not executing it. That is what Agent Dugan should have done here. Because he didn't, we ask this court to reverse. Thank you.
Thank you, counsel.
Good afternoon, Your Honors. Eric Meinerding for the United States. I'll be addressing the Fourth Amendment question today. My co-counsel, David Bainbridge, will address the 924C conviction. On September 27, 2023, Mr. Longabaugh made a choice to run into First National Bank gun in hand. Critically, he made a second choice, to tell Google he was there. Because the Fourth Amendment does not prohibit law enforcement from accessing Google's location history information in this case, we ask this court to affirm. There are three independent reasons to support the lower court's decision. First, a search did not occur in this case. Second, even if a search did occur, it was authorized by a valid warrant. And third, even if the warrant was defective, it was relied on in good faith. To the first point, a search did not occur in this case. Rather, the facts here fall squarely within the third-party doctrine.
Can I ask you a question? So suppose, hypothetical, so suppose I go back after the oral argument and my phone is missing from the chambers. And the police come and the only people in the building are the people in this room. Are the police able to detain everyone in this room and search them? as
No, Your Honor.
suspects?
No, Your Honor.
Okay, so why isn't that any different than what the police did here, which is they assessed a group of people who were in a certain space, they knew a crime had occurred, and they effectively conducted a search?
Your Honor, I think that wasn't this case of what happened here for two reasons. First, because the information that the officers analyzed was ultimately meaningfully voluntary. I think that goes to the second factor that Carpenter discussed, that my friend just discussed. Also, that the information is a lot less sensitive here than would be to comb through every single person's pockets. I think that also distinguishes what my friends discussed in Ybarra, that there's a big difference between actually touching a person's physical body and examining a brief amount of digital information about them that they allowed a digital company to collect.
But the companies collect so much information, frankly. The phone might reveal a lot more than what they find on the person.
Your Honor, I think that it depends then on what the actual specific type of information collected on your phone. I agree with what your proposition says, and I think Riley versus California is correct on that as well, that phones do potentially carry a lot of information. But Carpenter doesn't just outlaw any kind of information we get from phones. It actually gave us really clear guidance. I think factors, per Your Honor's question of my friends on the other side, Carpenter gives us clear factors to analyze what technologies I think fall within the third-party doctrine. It looks at two things: whether or not the kind of information produced by the technology is inherent to the operation of the device. In Carpenter, it's impossible to use a cell phone without producing CSLI. You can't use a microwave without producing microwaves. You can't use a cell phone without producing CSLI. That's the first factor. Can you use the technology without producing the information? The second factor then is the technology indispensable to participation in modern day society. And the Carpenter Court clearly concluded that a cell phone is indispensable. The same is not true about Google's location history service in this case. And it's key. Google's location history service is an independent service. Judge Hardy noted the difference between Google Maps, which can operate totally independently of Google's location history service being enabled or disabled. And I think that is rectified by the fact that 60% of Google users, and I want to clarify that 60% statistics, I think it's really important, is that 60% of Google account havers. And I think we can couple that notion with Carpenter, the fact that most people have cell phones in the modern day society, that most people that have a Google account most likely have a cell phone. So even if they're right on the margins, that maybe 60% isn't the correct statistic.
Does your argument totally rule out the sort of notice point that your friend on the other side was making, that you get this little button that comes up and you click on it amongst 100 things you're clicking on in a few minutes? Is that relevant at all to your analysis?
Yes, Your Honor. I think all I was clarifying is that it just makes the case all the more easy. You could disagree with us and agree with my friends that that notice was not voluntary, that it wasn't sufficient, and we would still win based off of the analysis of Carpenter. But the fact that Google did explicitly tell Mr. Long about that they would collect this information, and I think Judge Richardson in the Fourth Circuit, when analyzing this question, looked at this issue and said, if you read that opt-in screen, it tells users that they will collect information even when they aren't using
Yeah,
the
I mean,
app.
people don't, I mean, I don't know, maybe you read those when they come up, I don't. So and I just think, most people don't think that when they're clicking on something on the phone that they're giving access to their every movement to, some technology company.
Your Honor, I think that could be true in long terms of services. So we've all used, for example, Apple products give you this paragraph after paragraph after paragraph. We skim to the bottom, hit click, move on. This is a really simple amount of information. There's really only about 2 sentences in. You could expand it and it would give you about 4 or 5 more sentences. There's a lot less information. And I think the Fourth Amendment still respects the agency of Americans, to Judge Hardy's question, that people have the
So you're saying
agency.
it was knowing, this was a knowing, all these users are knowingly turning over their information to these companies.
Yes, Your Honor.
Yeah. So if we maybe you can go back to your prior point, but if we disagree with you on that, if we don't think that this is really a knowing, voluntary release of information to these companies, and your other point was, can you go back to that point? Because I'm
Of
sure I
course.
fully followed it.
Yes, Your Honor. The information here is very insensitive. It's not the same kind of information as Carpenter's. So I think we can analogize here to Smith and Miller. Smith considered phone numbers dialed from a home phone. I think it was unavoidable. There wasn't necessarily this clear kind of consent. And also bank records. Most people have to have a bank. You're going to produce bank records. So I think both of those were involuntary, but also the information in those cases was not sensitive. Judge Wilkinson contrasts bank records with the limited amount of Google location history information in the Fourth Circuit's case, which was actually an hour's worth of information. Here we're only dealing with 30 minutes, and said that an individual's bank records has far more information than a mere 30 minutes about them.
Counsel, in Carpenter, the Supreme Court was very careful to say they weren't trying to rule on future cases because they didn't want to embarrass themselves for the future, right, or something along those lines. And they did have between that case and Riley, you see this concern about technology and how invasive it is and how sort of undermining fundamental Fourth Amendment rights. And I think that's what our colleagues on the Fifth Circuit were picking up on in their decision in Smith. It seems like you have a very narrow description of what Carpenter held, but there are some fundamental ideas in Carpenter that I think maybe are being lost. Why isn't the Fifth Circuit right to sort of take those concerns expressed by the court in Carpenter and sort of expand those to a different situation?
Your Honor, I think the Fifth Circuit got it wrong and misunderstood those core concerns of Carpenter, because from the question presented to the last paragraph of Carpenter, you see an overarching concern with chronicles of information. That is information spanning over periods of months, as Judge Goodwyn noted in the exchange with my friends. This, even if we look at the minimum amount of information Carpenter considered, which was 7 days, the information we have in this case was 6 days, 23 hours, and 30 minutes less information. And there's not even an allegation that with any of the 30 minutes of information that was collected in this case, that a church was discovered, a home address was discovered, a synagogue, a Planned Parenthood visit. None of that sensitive information was discovered. And that distinction does matter. We can look to the Supreme Court's contrasting opinions and Knotts and Cara. Both of those
The effect of your rule essentially is that everyone is under surveillance all of the time, essentially, right? Because we all have phones, and we're all kicking data to a number of technology companies. So in essence, we are, under your practice, we are all constantly 24 hours a day under surveillance, effectively. And your rule is, well, if they only ask for 30 minutes of that surveillance, it's okay. And if they ask for 7 weeks, it's not okay. But isn't the point that we're just all constantly under your client's watch?
No, Your Honor, I don't think Americans constantly are under surveillance under our theory any more than they would be under surveillance due to the security cameras that are constantly around streets, banks, and the like. And I think
Because surveillance cameras capture every corner, they capture a lot, but they don't capture every movement in daily life.
Of course not, Your Honor. They don't collect everything, but I think then
The phone does.
The second point of analysis here is also Americans can still opt out of those digital technology companies. There are a variety of privacy-conscious competitors to Google.
So the rule is
to
we're
Apple.
all under surveillance, but we have the right to opt out of the surveillance if we hit the right buttons.
No, Your Honor, because I think, and we can focus specifically on the information collected in this case, is it was turned off by default. We do have to opt in, and 60% of Google users don't make that decision. I think our theory still applies. Americans can retain their agency and their privacy. But even if the court is not persuaded and does think that a constitutional search occurred here, that's okay, because Agent Dugan procured a warrant that struck the balance between Americans' privacy and their security. The warrant here was sufficiently established based off both probable cause and particularity. And while the technologies are new, the principles are simple.
Would it have been sufficient, would the information that the agent gave to the magistrate have been sufficient if he didn't say that he saw the outline of a thing that was roughly iPhone-shaped in the pocket of the suspect?
Your Honor,
Would
I
it be
think,
enough just to say there was someone here, and we never saw them use a cell phone or carry a cell phone, but everyone knows, the Supreme Court has said that everyone has a cell phone, therefore we can get this data?
Your Honor, I think that would be a much closer call. That isn't the case here. I think in that instance, both Carpenter and Riley have a strong indication that most people do compulsively carry their phone. I think the second question that would be relevant in a situation like that is what kind of geofence warrant then is the officer applying for? Google's not the only technology company. The reason there is probable cause here is because Google effectively and repeatedly had offered itself out to law enforcement. They created a whole three-step process for law enforcement to use to collect that technology. And because that had been reliable over and over in the past, I think that increases the likelihood that running a Google geofence warrant would have revealed helpful information to the bank robbery investigation. And I think this warrant is very similar to a similar warrant that we saw in Zerker versus Stanford Daily. It allowed officers to search a third party's place for evidence of an unknown suspect. Here, officers were allowed to search a limited part of Google's place, that is their sensor vault, their servers, to find evidence of an unknown suspect.
Yeah. I guess when you use the word particularized, the initial request to Google produced 32 names, I think?
Yes, Your Honor, 32.
Okay, that doesn't feel so particularized to me. I mean, if you go to a house, you might find one person there, two people there. You know, usually when police work is happening, you have a couple of suspects in mind. Here, this was a pretty wide net, 32 people.
Your Honor, I think just to clarify the scope of what happened, information about 32 people was discovered. This wasn't akin to actually searching 32 individual people.
There's like 32 suspects, though, I guess, at the outset, that this broad use of technology brought the police to. It just feels very different than traditional police work.
Your Honor, I think it's rather similar to the traditional police work that was done in Stanford Daily, where in that case, officers would have gone to the student newspaper and examined a variety of photographs in order to try to identify the suspects in a riot that had happened at a hospital earlier. So they looked at every single person whose photo had been taken by Stanford Daily that they were able to access, which would have included more than just a couple of suspects. They would have been looking at photographs of plenty of other unrelated people, just how in this case, the officers looked at unrelated data of anonymized accounts. That's also, I think, important to underscore about how sensitive this warrant was, is the information until step 3 remained anonymous. And that was key to maintaining the balance between privacy and security.
Counsel, in something you sort of glossed over in your brief, you described it as a back and forth between the agent and Google. But certainly the agent didn't narrow his request down very much from step 1 to step 2, but Google pushed back. Are we reliant on Google to ensure that these warrants stay within the legal bounds, or is there some limitation that we should be imposing on law enforcement?
Your Honor, we shouldn't rely on Google, and the warrant did impose limitations on law enforcement. Agent Dugan, and this I think addresses what happened at step 2, even when he wanted as much information as possible, that's the verbatim quote from the record, he never asked for more than 30 minutes of information. And that limitation is controlling here. Because temporal limitations have a geographic component. People can only travel so far within 30 minutes, especially right after a crime that just occurred after a bank. People probably aren't going to be going anywhere for a couple of moments until police have had an opportunity to interview them. There's only going to be a handful of people fleeing from the bank at that point. Good chance one of them is the suspect. But even if the court doesn't think that there was sufficient probable cause or particularity in this case, Agent Dugan did. He believed in good faith that this warrant had sufficient probable cause.
Did he consult with any lawyers
No,
before
Your
he
Honor.
sought the warrant?
No, Your Honor, he didn't consult with lawyers. He consulted with the one person that the Constitution vests authority to make these decisions to, the independent magistrate. And this is a far field from the case that my friends rely on, Groh versus Ramirez.
Well, that's a little bit different. I mean, that's lawyers would be pre-consultation, I guess. If you think of the magistrate as a counselor, I think I would view their role a little bit differently. They're saying yes or no, but they're not. He could have talked to a lawyer in advance to decide whether he should even approach the magistrate, and if so, how he should do it, and what information would be most helpful to present the warrant request.
Your Honor, I think a step like that could have been more helpful, but the Supreme Court has not required that step ever in order for the good faith exception to apply. United States versus Leon identifies 4 circumstances in which the good faith exception does not apply once an officer procures a warrant. Speaking to an attorney is not one of them. It is only if the warrant is not based off an indicia of probable cause or there's sufficient particularity. But here, where Agent Dugan executed a warrant that had at least an indicia of probable cause and was particular within its time limitation, he exercised good faith and the evidence should be admitted. Thank you.
Thank you, counsel. You may proceed.
Thank you. Good afternoon, and may it please the court. Alex Webb for appellant. This case is about common sense and ordinary meaning. Now, this statute is complicated, and it's susceptible to multiple different interpretations. But this court should choose the interpretation that best harmonizes statutory text with statutory purpose. The government disagrees, and instead, at page 28 of their brief, they argue that this court should check its common sense at the door and adopt wooden logic. That is wrong, and this court should reverse for 2 reasons. First, because section 2113A is indivisible, and second, because attempted bank robbery is not a crime of violence. So first, section 2113A is indivisible because robbery and extortion are 2 means of committing one crime. All of the government's arguments about divisibility boil down to just one point, which is that robbery requires force while extortion does not. That's true about their common law argument, pointing out that there's this consent element of extortion. That's just another way to say that extortion is not forceful. It's also true about their textual argument, that the word take implies force while the word obtain does not. But one part of the statute being forceful and another part being non-forceful does not make the statute divisible. And that's because in every divisibility case in the crime of violence context, a court will be analyzing a statute where one part of it is forceful and another part is not.
Yeah, but you don't think there's just some fundamental difference between robbing someone, taking something from them, and then extortion, which is sort of, coercing them to do something, maybe tricking them, maybe, blackmailing them. Those just feel fundamentally different. I realize that maybe the outcome is the same, that you've taken something that, you've received, won't use the word take, you've received something that's not lawfully yours, but the means seem very different. That seems very different conduct.
I think you're right that they do have some differences, Your Honor, but of course, 2 means of committing one crime will always have some differences. That's why they are different means. Our point here is that the difference cannot simply be that one is forceful and one is not, and that's because every statute where a court is analyzing divisibility in the crime of violence context has that same setup. And so this entire area of law exists in order to decide if we can separate the forceful thing from the non-forceful thing. So it cannot be the test that the simple fact of one being forceful and the other not makes them divisible. That would be circular.
Well, I mean, the test really focuses on the text, and it's a very odd thing to have. You say that the 2 provisions are the same, right? I think you call them synonymous in your brief. Why then have a whole nother clause with another verb? Why not just add, extortion to the list of things that you can do to take? Why do we have obtained by extortion different from take by intimidation or force?
To be clear, Your Honor, we don't think robbery and extortion are synonymous. The things we think are probably synonymous are take and obtain. But that aside,
you said that in your brief, and I mean, I feel like those words have different meanings. Like when something is very easy, you would never say, well, it's like obtaining candy from a baby. It just doesn't have the same, right? It just doesn't have the same ring to it. So it seems that those words aren't exactly synonymous.
You're right, Your Honor. Again, we think those are just getting at the distinction between forcefulness and non-forcefulness. And if that was the test, then all the statutes out there that courts have held have a forceful component and a non-forceful component that are part of one crime would suddenly become divisible overnight. But the fact remains that courts do not conduct divisibility analysis in this way by only looking to the forceful or non-forceful nature of the crime. You're right that another thing they do consider are some textual features about whether the statute is divisible. And we point to 4 of those textual features at page 13 of our brief. Robbery and extortion appear in the same paragraph. They have the same punishment. They aren't separated by a semicolon. And the use of the word by before each of them indicates they are means by which to do a crime. And we acknowledge that none of these factors standing alone is dispositive. But the fact that they all point the same way here, that means something. Congress had all these tools in their toolkit that they could have used to make this statute divisible, and the fact that they chose not to use those tools has meaning. The government's only counterexample is the Hobbs Act, which similarly has the same textual features in it, and yet the Hobbs Act is still divisible. But the Hobbs Act is different in one key respect. Every court to hold that the Hobbs Act is divisible focuses exclusively on Section B of the Hobbs Act, its definitions section. And even more importantly than defining robbery and extortion, it defines them in separate subsections. So robbery is subsection B1, and extortion is subsection B2. Remember that being in separate paragraphs can make a crime divisible. Being in separate subsections is even greater evidence of divisibility. And so that's why the Hobbs Act doesn't apply here, and the 4 textual features that all indicate divisibility mean something.
Now, I think the government makes the point in their briefs that the Hobbs Act is the most informative thing we could look at because it's a nearly analogous statute. And if that's what Congress intended there, why would we not interpret the provision here to have the same separate meanings and divisibility?
Judge Hardy, I think the key word in your question is that the Hobbs Act is nearly the same as this statute. The difference is that in this statute, there's no definitions section, and more importantly, robbery and extortion only appear in that one paragraph. They do not appear later on in the statute in separate subsections. So that is the distinction. In the Hobbs Act, Congress put robbery and extortion in separate places. So while it's true that they're in one paragraph in Section A of the statute, they are in separate paragraphs and indeed separate subsections in Section B of the Hobbs Act. And that is the key distinction. So because Section 2113A is divisible, it is categorically not a crime of violence because extortion can be committed non-violently. That alone is independently sufficient to reverse. But there is also a second reason to reverse, which is that attempted bank robbery is not a crime of violence. The government would have you believe that the only type of attempted bank robbery Congress intended to punish was where a defendant actually uses force, violence, or intimidation, but still somehow falls short of completing the robbery.
And by you say the only one the government intended to punish, you mean under this statute?
That's right, Your Honor,
But the government says there are at least 3 other statutes that an attempted bank robbery could be charged under.
Your Honor, the government points to 2 other statutes that a bank robbery could be charged under in those circumstances, but I would note that neither of them were enacted at the time this statute was enacted. Both of them came later. So the larceny provision came in 1937, and of course the other statute they cite was enacted in 2002. But at the time of enactment in 1934, which since we're interpreting this language that has been in the statute since enactment, that's the relevant period of interpretation. At that time, there was no other crime that a non-forceful attempt could be punished under. And so for that reason, it makes no sense for Congress to write these words with the intent to let the defendant who doesn't use force off the hook. Let's return to that text now, which is found on page 3 of our brief. It says, "Whoever by force and violence or by intimidation takes or attempts to take from the person or presence of another any money from a bank shall be punished." And again, the operative question here is whether that force clause, by force and violence or by intimidation, means that the phrase attempts to take, and more specifically the word attempt, requires force during the attempt. But it does not, because that force clause's purpose is merely to define the elements of robbery. Robbery's legal definition is a taking by force and violence from the person or presence of another. So functionally, this statute is just the equivalent of whoever robs or attempts to rob a bank. And that's important because the word robbery never appears in the text of section 2113A. So the only reason we know this is a robbery crime, the only reason we know what its elements are, is because the force clause is there. That is its purpose. Its purpose is not to require force during attempts. And because this statute is functionally the equivalent of whoever robs or attempts to rob, it is not a crime of violence, because the Supreme Court in Taylor held that attempts to rob are not crimes of violence. For example, a defendant might go stake out a bank, buy a gun, put a ski mask on, and drive to the bank. But if he's arrested in the parking lot, he hasn't yet used force and violence.
Why wouldn't you use some type of factually based analysis to determine whether or not a particular robbery is a violent crime?
Your Honor, I agree that would be a more intuitive approach, and judges for decades have agreed with that as well. But the Supreme Court has reiterated time and time again that we unfortunately have to use the categorical approach for crime of violence analysis. And the categorical approach, intuitive or not, counsels that we can't look at the facts of any given case. But in the hypothetical I just mentioned, that bank robber who drives to the parking lot of the bank with a gun and a ski mask, he hasn't actually used force and violence.
But what about in this particular instance, in this particular case, what if this, changing the facts on you a little bit, what if he had just cracked open the bank teller's head with the butt of his gun, then he notices the police officer and he runs out of the door and he doesn't complete the robbery? That's an attempted robbery also.
I agree, Your Honor.
And you're saying, but it's not violent. We just
Exactly.
have- we just had
What
a
I'm
little skull fracture, amongst friends.
Unfortunately, I don't think the Supreme Court's categorical approach has much sympathy for skull fractures in any given case, Your Honor. And I agree that that would be a better approach to use, but the Supreme Court has reiterated that we must use the categorical approach no matter how odd it may appear. And it counsels that if it's even possible to commit this crime without using force or violence, then it is not categorically a crime of violence, and the sentence cannot be enhanced.
You know, I might agree with you on the second argument, but the more you use the phrase robbery to define, or to sort of categorize the first sentence or first half of the statute, makes me just, again, think why that clause seems very different than extortion. I just don't think of extortion necessarily as robbery. And so I understand why you want to call it robbery, attempted robbery, for the purposes of the second argument, but it then, in my mind, sort of divorces it more so from the notion of extortion, and that would be why this is divisible.
Your Honor, to return to divisibility for a second, again, we'd agree that robbery and extortion are not identical, but they are fraternal twins. And that's because even though the nature of the threat differs, even though the threat of robbery is forceful, or the actual...
They just feel different in kind.
They are different in kind, but again, anytime there are two means of committing one crime, there will be some differences between those means. Otherwise, there would just be one crime with one means.
But some means are more like other, it's hard to argue this in a vacuum, but some means are closer to each other than, this is like a wider gap. These feel like really different types of offenses that are plotted differently. Maybe extortion might feel sort of more white collar, more in the business industry, potentially. They just feel very different in kind to me.
I acknowledge that they feel very different.
Statute could have been written differently, but just my sense of it is that these are sort of different offenses.
I acknowledge that they feel different, and certainly if it was battery and murder, we would not be arguing that they are indivisible. But I think the Fourth Circuit's decision in U.S. v. Fuertas is instructive. There, the court analyzed Section 1591, which analyzed the crime of sex trafficking by force, threats of force, or fraud. Now, fraud seems very white-collar to your question, Judge Readler. And force, sex trafficking by force, of course, seems very different. One is forceful and one is not. And yet the Fourth Circuit still concluded that that statute was indivisible because of the way that the statute and its text treated those crimes as different means,
But
despite them feeling
You didn't
different.
have different verbs.
No, they didn't, Your Honor, but again...
Different verbs in two different clauses.
Again, Your Honor, I think different verbs is not doing the entire analysis because these take and obtain verbs, that's just going to the forceful, non-forceful distinction. And the test for divisibility cannot be whether one is forceful and another is not. Because again, this entire inquiry is set up to understand and decide if we can separate the forceful thing from the non-forceful thing. So it's circular and conclusory to say that just because one is forceful and one is not, that you can separate them. But to return briefly to the crime of violence portion, the loose end that the government hasn't explained is why Congress would criminalize only forceful attempts. And without an answer to that question, this court must reject their interpretation and instead prefer an interpretation that harmonizes statutory text with statutory purpose. For those reasons, we'd ask this court to reverse. Thank you.
Thank you, counsel.
Your Honors, and may it please the court, my name is David Bainbridge. I represent the United States on the 924C conviction. If there is any crime in the United States Code that constitutes a crime of violence, surely it's the one that starts with the words, whoever by force and violence. Because the district court correctly held that attempted bank robbery under 18 U.S.C. section 2113A constitutes a crime of violence for purposes of 924C, we ask this court to affirm. We have two main arguments. First, 2113A's first paragraph includes at least two crimes, bank robbery and bank extortion. Because those crimes are divisible, the court should apply the categorical approach to each of them separately. And second, both completed and attempted bank robbery under the provision constitute crimes of violence for purposes of 924C. I'll start with divisibility. When the Supreme Court sets out to determine what constitutes a crime of violence for purposes of 924C, it asks what is the least culpable conduct for which a person could be convicted of the underlying offense. But the necessary predicate question is what counts as the underlying offense, and to determine that, the court applies the divisibility analysis. And when the court applies divisibility, it asks, are there multiple crimes in the underlying statute, or is there just one crime but multiple means of accomplishing that crime? My friends on the other side argue for indivisibility based in arguments variously based on functionalism, policy, and purpose. And we think we win on each of those arguments, but you don't even have to get there because the text here is dispositive. There are at least four reasons for divisibility here. First, Congress uses two separate verbs to articulate the two separate crimes, so the action in each of the two crimes is different. Second, Congress uses two separate adverbial phrases to articulate the two separate crimes, force and violence or intimidation, and extortion for the extortion offense. Third, they do require force for the robbery offense, as my friend reiterates, and they don't for extortion. That is an indication that these are two different crimes. And finally, robbery has to be done from the person or presence of another. It is a more personal crime. This is another element that's not included for extortion, which is just another reason why robbery and extortion are divisible offenses.
What was it? Can you explain the last point a little more? Robbery could be committed in the presence of no one else, right? A bank robbery?
Your Honor,
I didn't even understand the point, but you could rob a bank at night. There's no one there. So,
yes, Your Honor. So actually this statute, because it requires force and violence or intimidation, and because it has to, the statute does require it be from the person or presence of another. That comes after the verbs. We do think it likely has to be done in a personal way. It has to be done.
Okay, then I didn't understand the point you're making about someone's presence. Do they both have to be done in someone's presence? That's why it's.
Oh, yes, Your Honor. My point is that extortion does not require that presence and robbery does. And the point there is just Congress in 2113A's first paragraph lists the elements of robbery, and none of those are elements that you have to prove during extortion, which just indicates that extortion is a substantively different offense.
So it might have been easier for us if Congress had broken these out into separate sections, but they didn't. Does that matter?
I don't think it does, Your Honor. And that's because, first of all, there's a practical answer. The Congress that added the extortion provision came along 40 years after the Congress that put larceny and burglary in there. The extortion Congress came along in 1986. The other reason is that the Supreme Court has never required that Congress use a coherent scheme to indicate divisibility, and that instead they just ask, are there two substantively different crimes? And this leads me to the example that we give in the brief, the Hobbs Act, which my friend discussed. The reason that the Hobbs Act helps us is because, first of all, the action there was coherent. It was delaying, obstructing, or otherwise affecting commerce by robbery or extortion. So it was the same thing that was being done, in a sense, the same verb, and it was being done by robbery or extortion. And there was no break between those two, robbery, extortion. There was no semicolon, there was no subsection break, there was no paragraph break. My friends are right that there was a definition, there were definitions under 1951 B1 and 2, But if the only difference between that statute and this one for purposes of divisibility is the definitions, I don't think that helps my friends much, because the way that Congress defined robbery there was using force and violence and using it against the person or presence of another. So, and the language is not precisely the same, but once again, robbery there required violence. So if the only difference is that there, they actually spelled out in different subsections the definitions, I don't think that helps much, because in 2113A, they once again required force and violence.
Counsel, can you respond to the appellant's argument? And I hopefully I'm articulating it correctly, but I think what they're saying is you wouldn't be doing this divisibility analysis unless you were first asking the predicate question about, is this a crime of violence or not? And so, and then they're saying, well, you're only asking that question because there's the presence or absence of force. So it's a little strange, and they describe it as circular, to answer the question of, is there a presence or absence of force, by saying, well, is there the presence or absence of force? When you get to the divisibility analysis. So I think what they're saying is that can't be, even if obtain and take are different, that can't be what answers the predicate question. Can you respond to that?
Your Honor, I think that's on its own, that might be right. If the only difference between one crime or one means and the other is that one required violence and the other didn't, that might not be enough. Our argument here is that's one indication that they're different crimes, and there are three other textual reasons. And this really goes to the fundamental difference. And the first one is the difference between the verbs that they're using. Where they require force and violence or intimidation, they include a specific verb. And the extortion offense is something else is going on. It's the verb obtain. And I think to Your Honor's question, and certainly to my friend's argument, just the fact that take and obtain are similar words, in fact, even if they're synonyms, I think that's all the more reason why that this argument is helpful for us, because if they're just the same words, then Congress could have very easily just added extortion right after force and violence or intimidation. It would have been whoever by force and violence or by intimidation or by extortion takes or attempts to take from the person or presence of another. Instead, something else is going on with the verb obtain. And if you take the point for just that, that's indicative of divisibility. But if you peel it back just one layer and look at what that fundamental difference between the verbs signifies, it has something to do with this idea of consent. And consent is not just, we don't just bring this up to say that robbery requires violence and extortion doesn't. It's a dividing line that has been a dividing line between the two substantive offenses going all the way back to the common law. And it's not just to signify that one requires violence and the other doesn't. It's to say that these are different crimes.
Yeah, and I think your colleagues described that distinction as a legal fiction, that we make this distinction now, but these common law distinctions shouldn't have any meaning here in federal court, and second, that they weren't real to begin with.
So, Your Honor, we agree in the sense that in some sense that it's a legal fiction. This is what Judge Pryor talks about in the Harris case for the 11th Circuit. But that Harris case is actually really helpful for us because Judge Pryor illustrates that it's a legal fiction that has bite, because extortion in American statutory law was developed to plug a loophole in robbery law, because the robbery offenses typically required violence, and courts needed a way to somehow criminalize robbery that was done non-violently. And so at least in American statutory law, extortion was added in to plug that loophole, and that's the same opinion that my friend cites for this idea of take and obtain as a legal fiction. In some way, it's just at least a label for identifying that different things are going on here. To Your Honor's second question as to the common law, my friends cite various cases, Carter, Bell, and Taylor, for the idea that we shouldn't use the common law. Those cases stand for a very different proposition. Take Carter, for example. The Supreme Court there, in an opinion by Justice Thomas, said where you can't use the common law category of a crime to supplant or to override the textual elements that are in a particular statute. But then he went on to say, where there are words in the statute that have a common law meaning, you can absolutely look to the common law to determine what the contours of the individual crimes in that statute are. So to the extent that we're using common law, and once again, we don't think you even need to get there. We think you can just look at the text for divisibility. But to the extent that you want to look at the common law, these were different offenses at common law, and one of the dividing lines between the two of them was the presence of consent for the the extortion offense, and the lack thereof for the robbery offense.
So this is a hard question. I think we'd all agree. That's why it's a good moot court problem.
Yes, Your Honor.
But you're asking us to, as trained, legal experts, to dice this language. It's pretty hard to understand. You want us to potentially go back to the common law and try to figure out what our common law distinctions. If Justice Gorsuch was here, he'd probably ask you about the rule of lenity. And he would say that, in close cases where it's just, a defendant's probably not, can't fully understand or wasn't fully on notice of what's illegal, of what sort of conduct is wrongful, that, maybe the court should rule in favor of defendants and against the government. Does that principle apply here on such a hard case that we're having so much trouble deciphering which way the language leans, and the consequences, if we read it in your favor, are pretty significant against your friends on their side, their client?
It doesn't, Your Honor, and that's because even under Justice Gorsuch's strongest articulations, lenity doesn't kick in unless there is ambiguity as to the application of a legal question to a particular defendant. And so it's not, the question isn't in the abstract, are the words in this provision ambiguous, or is there ambiguity as to this particular provision? And I'd point the court, for example, to Yates, where the court is asking, is the statute ambiguous as to whether fish are tangible objects? And many times when the court asks this question, they ask, is the statute ambiguous as to this individual's conduct? And to introduce lenity here, the court would have to say that the statute was ambiguous as to Mr. Longabow's conduct in particular, and that he would have some idea that it was ambiguous as to whether the crime that he committed was a crime of violence. So the question is not whether the resolution of this case on divisibility or on attempted force and violence is ambiguous. It's whether it's ambiguous as to his particular conduct. And the problem there is not with the categorical approach. It's with the idea that Mr. Longabow would have to be arguing that he was not on reasonable notice that going into the bank, flashing a revolver, zip-tying people to the ground was not a crime of violence. And I don't think that's a tenable position.
Do you want to shift to the second issue?
Absolutely, Your Honor. So our argument here is just that the plain text and the reasonable meaning of the statute requires that both completed and attempted bank robbery have to be done by force and violence. And the way that you get there is just by reading the statute straight across. There's the subject whoever, and that there's force and violence, whoever by force and violence or by intimidation takes or attempts to take from the person or presence of another. Takes and or attempts to take are a compound verb. Just as force and violence applies to takes, it applies to attempts. So every attempt has to be done by force and violence or intimidation. I take my friend to be arguing that this is essentially an attempted bank robbery provision. It is an attempted bank robbery provision, but it's one that has spelled out its elements very clearly. And just because in the abstract we might think of attempted bank robbery as not requiring violence, doesn't mean that's what Congress didn't require here.
So that argument helps you here, but in the broader game, doesn't it hurt you in a sense, in that this statute you're limiting the range of individuals the statute can be enforced against?
In some sense, Your Honor, I don't think it hurts the government because we have plenty of other options for prosecuting individuals who enter a bank and rob that bank, whether they use...
Justice Gorsuch would say there's too many laws.
I tend to agree.
In response to that, but go ahead.
Yes, Your Honor, I tend to agree. And this is directly in response to my friends, that prosecutors and law enforcement have plenty of other options. And it's even true, my friends say that it can't be that the first clause required violence, because in 1934, there wasn't a larceny provision and there wasn't a burglary provision, and surely it wasn't the case that courts were letting people off after non-violently robbing banks. In fact, that is precisely what happened, and it's mentioned 3 times in the United States reports, at least. The first one's Jerome versus the United States in 1943. The second one's Prince versus the United States in 1957. The courts there said that the reason that Congress decided, at least in part, to add larceny and burglary into the same provision is because courts had to let nonviolent robbers go. So my friend's concern that at the time of the enactment, this particular statute couldn't cover all crimes is exactly right. It didn't cover all crimes, and the Supreme Court recognized that as recently as 1983 in Prince versus the United States, another case, Bell versus the United States, another case that they cite. My friend's argument here essentially boils down to the idea that, and the implications of it are, that Congress could never prosecute a forceful attempt because it doesn't work naturally in our minds. And while
on your last argument, are we just supposed to infer that the Congress was responding to Supreme Court decisions when it amended the statute?
No, Your Honor, the reason I bring this up is because if we're already in this conversation about the purpose of the statute being to prosecute all nonviolent or all violent offenses, I think one really helpful indicator of the purpose is the fact that the Supreme Court repeatedly reiterated that the Attorney General had asked Congress to add a larceny or burglary provision in to prohibit the nonviolent iterations of the offense. So once again, I don't think that the court should go about looking for the abstract purpose of the provision. But if we're going to go ahead and talk about what words work naturally and whether the statute would have worked, I think it's really important to understand the historical context there, and that the fact that at the time that it was enacted, it is just the case that courts were letting nonviolent robbers go, and because of that, Congress, at least in part, Congress added the bank larceny and bank burglary provisions into the statute. Finally, if there is any crime or if there is any time where Congress uses the words force and violence in the provision and requires that every conviction for that crime be done through that force and violence, the court should give that language its plain effect. We ask the court to affirm. Thank you.
Thank you, counsel. You have 2 minutes for rebuttal.
May I proceed?
Yes.
May it please the court, 2 quick points on rebuttal. First, on the geofence issue, and more specifically on whether the warrant was valid. Judge Readler, you asked our friends on the other side about whether this is just about the people being in the wrong place at the wrong time, and it is. Their response was the Vasser v. Stanford Daily case, but that is distinguishable, because in that case, there was only one expectation of privacy that was invaded, and that was the newspapers. But here, all 32 of the users had a reasonable expectation of privacy in their data. So there were 32 separate searches as to each of them when the government got that data. To get individualized data, the government needs individualized probable cause.
But I don't really want to interrupt you on your rebuttal, but it seems a little odd to say that people have a reasonable expectation of privacy in the data that they have given to their cell phone company, but they had no reasonable expectation to not have their photographs taken and cataloged by a student newspaper.
Your Honor, courts have held that people don't have reasonable expectations of privacy in taking public photographs of them. And as we've noted, people did have a reasonable expectation of privacy in their data because they didn't share it in a meaningfully voluntary way because the notice was inadequate. But moving to the crime of violence issue.
I've got a question for you, counsel. What about if the data only shows their presence in a particular place, just like a photo would show their presence in a particular place?
Judge Goodwyn, I think if the data only showed that they were in the bank, and indeed if the geofence was drawn only around the bank, that would not be a search because it could only show them in the bank. But this was an 80-acre expanse across a wide downtown area. Very briefly on the crime of violence issue, Judge Hardy, you asked the government about why their interpretation doesn't just turn on this force and non-forceful distinction. Their answer was that our argument on that point is right, but they point to 3 other things. All 3 of those things just collapsed back into the force and non-forceful distinction. You heard them say that the consent element is just to say that robbery is forceful and extortion is not. And for these reasons, we'd ask you to reverse.
Thank you, counsel. Court will take a brief recess.
You may be seated. We're going to take a brief recess while the judges deliberate. Excuse me. I'll make an announcement before we're ready. Sorry. But I wanted to congratulate all of the finalists. Please give them a huge round of applause. Judges are going to come back in and give you all their decision and give the oralists some feedback. So everyone, please rise once again for our panel.
Please be seated. First, I'd like to compliment both teams on your performance today. You did an excellent job. And to be perfectly honest, any criticisms I had would be nitpicking. And after a year of working on this, I don't think you want to hear my nitpicks. So I'll defer to my colleagues for their comments. Just saying.
All right, well, we don't need to drag this out. I feel exactly the same way. All four of you were outstanding. You're welcome to come argue at my court anytime. And it's really obvious the amount of work and practice that has gone into this. But it was difficult to do. It was not, but all four of you were excellent. But we had to pick a winner, or else we don't get our reimbursements. So, after it was very close, but at the end we decided that the winning team will be the appellees, Eric and David. Again, congratulations, guys. You guys were really outstanding.
Judge?
Sure. Great job. Really terrific. You're also welcome in my court anytime. And I worry that you all also know the case so well that maybe our questions even weren't all that imposing for you. So you batted them down quite easily. Really appreciate that. So you're all terrific. We had a very hard time picking the best team and the best speaker, but our best advocate speaker award goes to Alex.
And we'll turn the program back over to the Moot Court Board.